Hi, I'm Dustin Saldarriaga, an immigration lawyer with Scott Legal PC in New York City. And in this video, we'll be continuing our tour of the E-2 investor visa requirements by taking a look at the ownership requirement. In its simplest form, the ownership requirement states that the E-2 investor must own at least 50% of the E-2 business. But sometimes the rule isn't so simple, like when a private company owns the E-2 business, or when your co-owner is a national of a different treaty country. In this video, we'll explore these and other aspects of the E-2 investor visa ownership requirement. For additional resources on the E-2 visa and how to qualify for it, please take a minute to check out our E-2 visa webinars, which we've posted to our YouTube channel and will link to below. Our firm's blog, which is also linked to below, has hundreds of posts on the nuances of the E-2 visa and is an excellent free resource on this and other visa options. Finally, please remember that none of the information in this video is a replacement for hiring an immigration lawyer who can look at your specific case and guide you through the process. With that, let's dive in. Many people have found that the E-2 investor visa is an ideal option for those who want to own and build a business in the United States. The visa can be issued for up to 5 years and can be renewed indefinitely. There are no educational requirements that the applicant must meet, and the required investment amount can be low, especially when compared to options like the EB-5 investor visa. Two of the fundamental requirements for an E-2 investor visa are that the applicant must own at least 50% of the business, and they must be a national of an E-2 treaty country. In an earlier video, we focused on this second requirement, the nationality requirement. This video will focus on the 50% ownership requirement. As you'll see, these two requirements are closely related since the ownership of the business determines its nationality, which in turn determines the nationality of any E-2 employees that the company can employ in the United States. The basic ownership rule is that the E-2 investor must own at least 50% of the E-2 business that they're coming to the U.S. to develop. This is a requirement that applies both at the time of application and throughout the applicant's E-2 status. The moment the E-2 investor's ownership drops below 50%, they become ineligible for E-2 investor status. So it's critical that they keep an eye on their ownership share. If you're concerned that your ownership share might drop below 50%, for example, if you have a high-growth company that's looking to raise funds in exchange for equity, you might consider other options like international entrepreneur parole. We have videos, webinars, and blog posts on international entrepreneur parole on our YouTube channel and our blog, so please check those out if you're interested in this option. As I mentioned before, the minimum ownership requirement is 50%. That means the E-2 investor does not need to own a majority of the business. They can have a co-owner who also owns 50%. For example, a German citizen and an Italian citizen can own an E-2 business 50-50. As I mentioned before, the nationality of the E-2 investor determines the nationality of the E-2 business. As a result, when there are two E-2 investors who each own 50% of the E-2 business, the business would have dual nationality. In our example, since the business is owned by a German E-2 investor and an Italian E-2 investor, the E-2 business would have both German and Italian nationality. Let's take a minute to discuss why this is important, why the nationality of an E-2 business matters. An E-2 business can hire E-2 employees, but only from the country of the business's nationality. The process of applying for an E-2 employee visa is relatively simple and straightforward, especially when compared to other visa options that allow you to work in the United States. So this is an important benefit when you consider that the business in our example would be able to employ nationals of either Germany or Italy as E-2 employees in the United States. But what if our German national who owns 50% of the E-2 business has a co-owner who is a US citizen? No problem. As long as the E-2 investor owns at least 50% of the business, it doesn't matter who owns the remaining interest in the company. The other owner or owners could be US citizens, permanent residents, or nationals of any other country. One thing to note, and that we discussed further in our earlier video about the E-2 nationality requirement, is that a U.S. citizen or lawful permanent resident cannot qualify for an E-2 visa. So, if the German citizen in our example also has U.S. citizenship or permanent residency, they would not qualify for an E-2 visa. Also, an E-2 investor with more than one treaty country nationality must commit the business to a specific nationality. For example, if the German investor in our earlier example also has Italian citizenship, but they applied for the E-2 investor visa as a German citizen, they could not then enter the US on their Italian passport to operate the E-2 business. They must instead hold themselves out as citizens of the country under which they were granted the E-2 visa. Some applicants choose not to own the E-2 company directly. Instead, they might set up a foreign limited liability company or corporation, which then owns the E-2 business. This is fine as long as the E-2 investor applicant is the ultimate owner of at least 50% of the E-2 business. In other words, the government will trace ownership from the E-2 company through any intermediate legal entities, such as a foreign corporation, and ultimately to the individuals who are actually the company's owners. The E-2 investor visa applicant in this scenario would need to include in their application documents from the E-2 company showing that the intermediate company owns it. They'd also need to provide documents from that intermediate company or companies showing who owns them. Let's take an example. If a Canadian E-2 investor applicant owns 100% of a Canadian corporation, which in turn owns 100% of the US company, the applicant would include in their application documents showing that the US company is entirely owned by the Canadian company, and that the Canadian company is 100% owned by the applicant. This would demonstrate that the applicant owns 100% of the US company and therefore satisfies the ownership requirement. Remember that the E-2 investor must ultimately own at least 50% of the E-2 business, even if their ownership share is traced through intermediate companies that own the E-2 business directly. So, if the Canadian applicant in our example owned only half of the Canadian company, that would be fine as long as the Canadian company owns 100% of the US company. When the ownership structure is complicated, as it is in this example, we recommend including a chart in your application that clearly shows the ownership structure. We hope this video about the E-2 visa was helpful. If it was, please click the like and subscribe buttons below to stay updated on future videos about visa options and travel to the US. Thanks for watching.